The judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we're prepared to hear argument in Pittman v. Harris. And Mr. Haif, is it how it's pronounced?
Mr. Harf, Your Honor.
All right, please proceed.
Thank you, Your Honors. Good morning. May it please the court, my name is Julian Harf. I'm here on behalf of the appellant in this matter and the defendant in this case, Corporal Quentin Harris.
Can you move that mic a little closer to you?
Yes, sir.
Thank you.
Your Honors, of course, this case is here from the Western District of Virginia. This is an excessive force case. Our position is that the district court improperly denied qualified immunity because under the undisputed facts, as found by the district court, Corporal Harris did not violate Mr. Putman's clearly established Fourth Amendment rights. I want to touch first on this threshold issue, which is whether this appeal can be heard on an interlocutory basis. Of course, our position is that it can. I want to note a case that was semi-recent, a Hicks versus Ferreira case, where this court said review is limited to whether the defendant is entitled to qualified immunity if the court takes the facts as the district court gives them to us. And that is exactly what we are asking Your Honors to do here today. We take no issue with the facts as interpreted by the district court. Our position is that the district court made an improper legal determination in the analysis of the undisputed facts as it found them, because it did not properly evaluate the totality of those facts. Now, what the plaintiff has done is he's latched on to this statement by the district court, where the court said on Joint Appendix page 328, because the facts are in dispute as to whether Harris had a reasonable belief that Putman may have been armed, the defense of qualified immunity cannot be resolved. I want to look at that statement.
So let me ask you one question. What position?
Judge Wilkinson, we're having trouble.
The dog. Can you hear me, counsel?
You're coming. You're
breaking it out, Your Honor.
Try it again.
Jackie.
I think
Jackie.
I think you're good now, Judge. Try it again.
Can you unmute yourself?
Yes, Judge
Can you
Wilkinson.
unmute yourself?
Can you hear me, Judge Wilkinson?
Jackie, they're having trouble hearing me.
Yes, sir. I'm in the courtroom with you. It's breaking up. Can you try again?
Yes, 1, 2, 3, 4. Can you hear me?
That sounds better.
All right. Al, can you hear me?
I can now. Yes, sir.
Okay. You stand by, Jackie, in case we run into any other problems.
Yes, sir.
Okay, counsel, all I wanted to know was what does the facts, what do the facts show? What position was Mr. Pittman in when the dog bit him?
Yes, Your Honor.
What position was he in?
So at the time that the dog was deployed and actually successfully bit Mr. Putman, at that time he had been pushed to the ground in an attempt for Corporal Harris to place handcuffs or his partner to put handcuffs on Mr. Putman. At that time he had started to raise off the ground. He was calling the deputies punks at that time. He said, "That's funny, punk," or something along those lines, and was starting to stand up. And that is when. But he
was lying on the ground.
Well, he was on his knees, Your Honor. He was getting on his knees. He wasn't prone on the ground at that time. He was trying to get up onto his knees at the time that the dog made contact. that answer your question, Your Honor?
Yeah, proceed.
So looking at this statement, what the court has said is this appeal is proper if the issue involves whether uncontroverted conduct represented the use of excessive force, which is an issue of law. That's exactly what we're asking this court to decide.
Let me ask you, so is it ever a question for the jury as to the reasonableness of an officer's interaction with the citizen? Like in this case, it seems like the district court seemed to suggest that, although it may have been worded inartfully, that, as you put it, even if you accept the facts as we have them, and we have the benefit of a videotape here, which is helpful, that all of the facts, both pro and con, suggest that this is an issue for a jury, and I, as a matter of law, can't determine whether or not this officer acted reasonably on these facts.
Your Honor, so two things there. I think whether it's a question for the jury in terms of reasonableness, I think the answer is no. I think when you look at our qualified immunity cases in the trial court, there are factual questions. So, for example, special interrogatories put to the jury, and then the court is ultimately making that legal determination as to whether the conduct was reasonable.
It's an objective standard, right?
Yes, Your Honor. I also think what the cases say, and specifically what this court has said in Elliott versus Leavitt, is the fact that the court uses these magic words, disputed fact, does not automatically mean that qualified immunity cannot apply when the actual question that the court is looking at is a question of law. And that's exactly what the court did here. The question is, which the court said, is whether Harris had a reasonable belief that Putman may have been armed. That is a legal, this court has said that is a legal question, which can be, this court can determine based on the totality of the circumstances, the undisputed facts that were found by the district court.
Well, okay, so let me ask you about that. So the facts that we have are, we have some evidence that Mr. Putnam had sent the text to his wife indicating that he was obviously distraught, that he was in fact armed. He had put a pistol in his mouth and was threatening to kill himself. So that, I mean, we've got that on text. It seems like the best evidence of what his state was. But when the officers arrived on his property, obviously it's his property, right? He has lawful authority to be on his property. The Second Amendment protects the right of an individual to be armed. So when they roused him, what's the basis for the officers coming upon him and then demanding that he turn around and put his hands behind his back, presumably to be handcuffed?
Well, at that point,
and does he know about that? Was he ever told about that?
What was he? I'm sorry.
Was Mr. Putman told exactly why it was that officers were interested in detaining him?
Not, Your Honor is corrected. Not at first, but eventually there's this back and forth where Mr. Putman asks for what, why do you want me to turn around? Why do you want me to put my hands behind my back? And one of the deputies says, "Did you say you were going to kill yourself?" And he responds, "No." That was the deputy's attempt at that point to tell him why they were there. Now, in terms of why they're coming upon him and having him, ordering him to get up, I think is clear from, is based on what knowledge they had leading up to that moment. So, obviously we have these text messages from Putman to his spouse, to his wife, saying, "I'm going to I have this gun. I'm going to use it to kill myself." They then come upon him. They have to track him deep in the woods. And this man is lying in what the district court noted was what the district court deemed as a shallow grave. He's then smelling of alcohol. There's cans of an alcoholic beverage near him. So we have, as the district court noted, signs, indicia of instability at this point. So everything that the text messages, that everything they saw with their own eyes at that point were consistent with what the text messages said. So at that point, that's the reasonable basis. And the court and the district court said they had a reasonable basis to seize him at that point. So the question is not, could he be seized? That the district court has said, the district court has said he could be seized. That question was answered by the district court. The question becomes, how much force can be used? Because the district court also noted, when looking at the grand factors.
I think the district court is is asking the question, if you had probable cause for an arrest or a seizure, um, why did you need the dog? What role did the dog play? You didn't see a gun in this encounter. But why wouldn't arrest or seizure be a less drastic means of handling the matter as opposed to putting letting a dog loose on him?
Your Honor, I think the goal was to seize him. And the case law is clear that we can use reasonable force to do so. I think what the officers are thinking at that time is, and what the testimony is that we have these text messages saying that he has a gun. This isn't this isn't just a abstract theory that they have that he may have a gun. This is something that came from Mr. Pubman himself telling his wife that he has a gun. So the use of the dog at that point, and again, this isn't an immediate use of the dog. This was after a 2-minute back and forth where they are giving him command after command to space away, turn around, put your hands behind your back. They are then telling him why they did that. And all the while, he's refusing those commands. He's swearing at the officers. He's telling them to get the F off my property. He's clearly showing signs of intoxication. He's clearly angry. The district court found that he was being combative and evasive. Evasive being another sign of suspicion. And after that 2-minute period, these officers they know they can seize it. They know they can use reasonable force to do so. At that point, the question becomes, well, what force is reasonable? Now, I will note that what this court has said it should consider is the force deployed is the force used at the time. So at the time the force was used, that's what we're looking at. At that time, we know that hands-on force wasn't enough because at that time he had been pushed. Mr. Pubman had been pushed to the ground, and he was trying to get up. And so then you have a situation where
You're skipping by the initial use of the dog.
Yes, Your Honor.
The reason he was on the ground was because the dog had been deployed and had knocked him to the ground.
Yes, Your Honor, that is true.
So
But
isn't that the question, whether or not that was a reasonable use of force in that instance, given as that Judge Wilkinson indicated that at least as best they could tell, there was no indication that they couldn't see a weapon. They couldn't see a gun.
Your Honor, I think, frankly, I think that's an open question. I'm not sure that that when the dog was initially deployed, the dog didn't make contact. So there was the force that we're all talking about here is a dog bite. That force didn't happen until after Mr. Pubman is getting up. So if we take that, so if we assume that is that there's essentially two times that we're looking at here, the first initial deployment and then the actual contact, the deployment was still reasonable. And certainly the fact that he hasn't tried to stand up by that point doesn't change that fact. At that point, again, we have information that this man is from himself, that this man is armed with a gun, that he is potentially intoxicated, that he's acting irate, that he's refusing commands. And frankly, that's the mechanism that this officer has to detain this person. Because he's got a leash, he's got a dog he's got a dog on a leash in one of his hands. So he's making that split-second determination at that point. Well, if I try to detain this person, which the court has said is reasonable, the district court said we can detain him, what is going to happen when I do that? And that is the reason that the dog was appropriate and reasonable to deploy at that time, because the officer does not have to be put in a position where he tries to simply use hands-on force and just put the guy's hands behind his back after 2 minutes of the guy refusing to do that, and risk the idea that this person might take out a gun that he said he had mere 2 hours earlier and shoot the officers.
Is it the fact that you just point that out, that the officers had evidence that he was armed coming from his own mouth via electronic text? If they didn't have that evidence and simply came upon him in this circumstance, no indication that he was armed, is that a different case?
Yes, Your Honor. I do think that's a different case. I think if the circumstances here are that we have no reason to believe, I think it's a closer case. I mean, I think it's a closer case. I don't think it's necessarily that it's not reasonable to use the dog, but certainly that's a different case. If we have no reason to believe for example, in Armstrong, when they know he's unarmed, and we've made that distinction on brief, that is a different case. This case, we have a credible, which the district court noted, we have reliable information that this man is armed. What we are not required to do is take the man's statements, and the district court noted that, well, verbally, he only threatened to harm himself. And then he said he wasn't armed. Well, the law is clear that we are not required to take Mr. Putman's statements at that time as gospel. We are not required to take that as truth, because a mere 2 hours earlier, he had said the opposite. And of course, we're coming upon him in all these strange circumstances and potentially intoxicated individual. When we have a reason to believe that he's armed and dangerous, we can confirm that by doing a hands-on frisk. That's clearly established law, of course, Terry versus Ohio. So the officers at that point knew that they could seize him. The question is how much force could be used. The district court said that the dog was too much, but didn't tell us what would have been reasonable. We know that some force would have been reasonable. We know that we have this information that he's armed, that he's suicidal. He's clearly in a state of mind that is not baseline. And for that reason, we believe this case is different than a case where we have no information that he's armed. Your Honors, I see my time is winding down. Just because of the technical difficulties, would you mind if I make a few more points?
All right, thank you very much, counsel. We appreciate your argument, and if my colleagues have questions, I'll let you stand up. Otherwise, we'll hear from you in rebuttal. All right?
Thank you, Your Honor.
Good morning.
Mr. Lucetti, let's hear your side of it.
Yes, Your Honor. Good morning, Andrew Lucetti. On behalf of the appellee, Mr. Dillard Putman, we respectfully request that this court affirm the district court denial of summary judgment on the basis that—
Let me just ask you a preliminary
Yes, Your Honor.
question, sir. Had you been the officers, how would you have handled this situation? I know you think that the way they handled it was incorrect, but what would you have done?
If I was the officer, I would have said, "Are you Mr. Putman?" And when he identified himself, I said, "Mr. Putman, your wife called and said that you want to harm yourself. Do you want to harm yourself? Sir, are you armed?" None of these questions they asked. They came upon Mr. Putman, and the district court found that Mr. Putman did not have a gun in his mouth, and he was lying calmly in the hole. And when they came upon him, they told him to get up, and he calmly responds, "Get up for what? I live here." Obviously, he didn't know why they were there. And
Well, let me ask you this. If would it have done any good to have asked those questions?
We don't know.
Given the fact that the district court found that he was non-compliant and that he was alcohol impaired and that he was swearing at the officers and all the rest, what good would those kind of questions have done with a very inebriated individual who is, in the district court's words, non-compliant and swearing and abusive? Why do you think
That's not what the district court said, Your Honor. I take umbrage with Mr. Harf's characterizations of the facts as the district court found them. If we look at the facts as the district court found them, the court found that Mr. Putman did not make any threatening movements or statements towards the officers. Joint Appendix 321. The court found that Harris ordered the canine to bite Mr. Putman after a mere 2 minutes of verbal instruction.
Well, let me just say this, that the district court characterized the individual's response as combative and said that he swore repeatedly at the deputies, that he had refused commands to turn around or face away. And so the question I have for you is, what good were the questions that you were saying the officers should have asked? What good would they have done?
I think they would have done some good, Your Honor. Mr. Putman was calmly asking the officers why they were on his property in the first instance, and they didn't tell him. They said, you say you're going to kill yourself. That's all they told him. They didn't say, we're here to detain you, not for an arrest. We're not here to arrest you. We're here to detain you for an involuntary mental health seizure. We're here to take you to the hospital to see if you are indeed a threat of harm to yourself. And this court has said that when the government's sole interest is preventing harm to the subject of the seizure, serious injurious force cannot be used until an immediate threat of harm that can be ameliorated by the use of such force. The district court found no such immediate threat of harm. And in fact,
Can I follow up on Judge Wilkinson's
Yes, Your
question? So you raise a good point. They could have done a number of different things, but that really isn't the test, I don't think. The question is whether these officers, given the circumstances in which they found themselves, acted with it. What I think the law is a wide range of reasonable conduct. And we have to keep in mind that the overarching objective of qualified immunity is to immunize all but the most incompetent and unreasonable of officers. So yes, they could have done what you suggested. They opted not to. And the district court found that they were entitled to seize your client. And the question is it reasonable for them to have done so in the manner that they did after giving him multiple warnings to turn around and, submit to their show of authority, and his refusing to do so. And I will admit to you that there's no evidence that he was physically combative, but he was verbally combative. So again, I guess to go back to just Wilkinson's questions, what were they to do at that point, having not done what you suggested?
they could have seized him without using the dog. In fact, the fact is that puts his gun, his rifle down and pulls out his taser, and indeed tased Mr. Putman.
Right.
We do not,
and you don't complain about that.
I do not complain about that because there's no significant injury, Your Honor. The dog.
So it's the result that
The significance of the injury is a factor to be considered in the Graham analysis, Your Honor. And this court has said in Armstrong.
But we have cases that say that once a dog is deployed, the amount of time that he is actually latched on to the individual is not the fault of the particular officer.
And we don't. The issue is the release of the dog in the first instance, Your Honor. Okay. And this court and the district court found at that time that Mr. Putman was not attempting to flee, or was he physically resisting when Harris released the dog. Rather, he was standing with his hands outstretched, repeating his demands to see a warrant as he had done for the past minute. Putman's refusal to comply with shouted commands, while a cause for some concern, do not import much danger or urgency into a situation that was in effect static impasse. Okay. That is a factual finding by the.
So let me just ask you a different question. So what's the factual dispute there? I mean, the judge seems to be.
The factual dispute.
Hold on.
I'm sorry.
The judge seems to be accepting the facts as they appear on the record and in the videotape. So what is the factual dispute?
According to the court, that a reasonable jury could find that a reasonable officer on the scene could have understood that Mr. Putman was armed, and that under those circumstances that and this is my belief of what the district court meant, Your Honor, is that under that circumstance, then there would be the qualified immunity would apply.
But is that the law? I mean, it's an objective test. So
I don't think that is the law, Your Honor. And I think Young v. Prince George County makes clear that just because a person is armed doesn't give the officers carte blanche to use any force.
No, what I meant is it the law that sets up a disputed issue of fact, or is it ultimately a question for the judge, assuming the facts are undisputed?
Well, I think it depends on the question, Your Honor. So, and then clearly whether there's a violation, I don't think it's material. I don't think it's dispositive, but it is material whether or not Mr. Putman, the officer, reasonably believed Mr. Putman was armed. Mr. Putman was not armed. That's undisputed. And it's undisputed that he had no weapons in his immediate vicinity as the dog and the dog handler went and searched the woods after they seized him and found nothing. So it is undisputed that Mr. Putman was unarmed, despite Mr. Harf's characterization.
Let me ask you this: was it reasonable to believe that Mr. Pittman was armed and had a gun somewhere in his waistband, given the fact that the text message that led the officers to the residence said that he was, her husband, Pittman, had a gun and was going, quote, to end it all.
Sure.
The whole reason that the officers were there was because the message from the spouse indicated that he was suicidal and at least and had a gun. Besides, the officers have this one report to go on. It's a very difficult situation for them. It's a very confused situation, and the question, I guess, is whether they were acted within a range of reasonable alternatives. And the text message would lead a reasonable person to believe that you had an inebriated and suicidal individual with a gun to carry out his avowed wishes. And I think they were the officers were trying to obey the respect the wife's wishes and save this individual from himself. And you wonder, well, is this a question of where no good deed goes unpunished? Because they were acting at the behest of a spouse, and they were trying to save this man's life. And so I'm just asking you why, in light of all that, isn't this?
Well, for one, while the district court found that Mr. Putman did indeed make those statements, and those statements from Mr. Putman, the officers on the scene did not have that information. The only information they had was that Miss Putman, Candy Putman, told them that her husband had texted her these messages and showed the officers these messages. And while the officers have the ability to rely upon that, it doesn't mean that those text messages are certainly from Mr. Putman. And in any event, when they come upon the scene, as the officers that Officer Harris and Officer Hayden that went up in the woods did not see the text messages. They were told by Officers Baldridge and Bowles that Mr. Putman was suicidal and that he had a gun in his mouth. When they approached the scene, Mr. Putman did not have a gun in his mouth. Mr. Putman did not have a gun in his hands. Mr. Putman was laying down, taking a nap. He woke up to see a dog staring down at him. And the first thing he was told was, get up or get your hands up. And he says, for what? I'm on my property. And instead of saying, because your wife called and said you're suicidal, he says, get up or my dog is going to bite you. That is unreasonable, Your Honor. The government's sole purpose in this case was to prevent Mr. Putman from harming himself. Not once did he threaten anyone, not the officers, not Ms. Putman, anyone but himself. And in that case, the government's sole interest in this matter is to prevent him from harming himself, and they cannot use serious injurious force to seize Mr. Putman until an immediate threat, more than an imminent threat, an immediate threat that can be ameliorated by the use of that force. Mr. Putman, when the dog was released, was standing with his hands outstretched, repeating his demands to see a warrant and asking why they were there, what had he done wrong to be arrested. And instead of telling him, they sick a dog on him and caused a significant serious injury, one that required life-saving emergency vascular surgery. This was a significant use of force.
So the first time the dog was deployed, he missed, right?
Absolutely.
Okay. So you don't have a claim for excessive force based on that, do you?
Well, I think the court has said we don't look at a granular moment in time, but we look at the whole event.
Well, your colleague on the other side says at that point, once he was on the ground, he began resisting, and that justified the second use of the
He did not. He was passively resisting. He didn't throw any punches. He didn't kick. He didn't jump up. He was laying on his side when the officer said, "Put your hands behind your back." How was Mr. Putman supposed to accomplish that command with his arm in front of him, lying on his side, without getting up on his knees, Your Honor? A reasonable jury could find that Mr. Putman was actually complying with the officer's commands to put his hands behind his back, and he was just saying, "You're funny, punk. You're effing funny, punk." He didn't, wildly gesticulate. He didn't kick his feet. He didn't throw his arms. He didn't buck his body. He just sort of tensed up. And at that time, he re-released the dog on Mr. Putman while Mr. Putman was being tased in the back.
You're putting a bit of a gloss on what the district court said, are you not? The district court did not find he was the kind of calm and compliant individual that you're describing.
No, the district court said that Mr. Putman was calmly lying in the hole when the officers arrived, and that the court found that Harris ordered the canine to bite Mr. Putman after a mere 2 minutes of verbal instruction without any particular action by Putman, shifting the dynamics or escalating the situation into immediate threat. That is the factual finding by the district court that this court is bound by. And under Armstrong, it is clearly established that that is unlawful, and every official should know that.
In the Armstrong case, the plaintiff was not swearing at the deputies, and there was no evidence that the plaintiff was armed or had a gun at all. And it was plain in the view of the majority that the plaintiff posed no threat of any kind to the officers, but that's not clear here.
The district court found otherwise, Your Honor.
And there was no tasing here. There was no.
He was tased as well.
All right. There was no shooting at him.
No, Your Honor. But the same, the interests involved are the same. The government's interest in Armstrong was prevent that Mr. Armstrong from harming himself. And the officers in that case had a warrant. The officers in this case did not have a warrant. They were on his property without Mr. Putman's consent to involuntarily seize him, to force him for a mental health evaluation. Mr. Putman denied sending those text messages. Here's the thing. It seems unlawful from a common sense perspective for officers to go onto someone's property and use serious injurious force to make him comply for a mental health seizure. Mr. Putman is not a criminal. No allegation that Mr. Putman threatened anyone except himself. He didn't threaten his wife. He didn't threaten the officers. And the court found those facts. And under the facts as the district court found them, qualified immunity is inappropriate. And we ask the court to affirm the district court's ruling in this matter. Do you have any further questions?
We thank you. Thank you very much.
Thank you, Your Honor. Thank you.
Counsel, do you have some time for rebuttal?
I believe I do, Your Honor, and I just want to make one or two very brief points. Your Honors, there was a significant discussion about the Armstrong case. This is what the court ruled in Armstrong. An officer cannot use force that risks substantial harm to the subject if, when dealing with a mentally ill person, that individual is, quote, unarmed and minimally threatening. That's why the district court was an error when it applied or when it compared Armstrong to this case and used Armstrong as its guidance, as its authority to deny qualified immunity, because it's impossible to watch the video in this case, keeping in mind the information that these officers had from Putman's wife, that he had texted her saying that he was suicidal and had a gun. It's impossible to watch this video with that information in light of all the other things, that strange circumstances that we're talking about coming upon him in, a mile from his house in the woods, or less than a mile, but deep in the woods, lying in this ditch, smelling of alcohol. It's impossible to know all that and then say that this man was, quote, unarmed and minimally threatening. Now, as an aside, and the court touched on this, I think it's telling that neither the district court nor the plaintiff takes issue with the fact that the other deputy, Hayton, used a taser on Mr. Putnam. The district court and the plaintiff rely on Armstrong, which is a taser case. So in other words, what they're doing is they're comparing the taser to the dog in this instance, which makes sense. This court has said that a taser is severe and injurious force. Now, what the court also said about tasers in that case, in Armstrong, said tasers are proportional force when deployed in response to a situation in which a reasonable officer would perceive some immediate danger that could be mitigated by using the taser. That's exactly what we have here. We had a reasonable officer believing that they perceived some immediate danger that could be mitigated by using the taser, which is why the other deputy used the taser, Hayton, and why Harris deployed the police canine. We would submit that if it's not clearly established that you can't use a taser here, it's also not clearly established that you can't use the police dog, especially in light of the fact that it's really Harris's only mechanism of force other than pulling out a higher degree of force in a deadly weapon. It seems like what the district court would have these deputies do is wait until there is a weapon out, a weapon pointed at them. And at that point, we're probably escalating to deadly force. So our position, Your Honors, is that these officers did not have to wait until this man pulled out the gun that he had told his wife he had a mere 2 hours earlier. And that based on the existing case law, that qualified immunity applies and the district court erred. I just want to point out briefly, I'm not going to belabor the cases I cited on brief, but I do think I want to highlight the Zuris case out of the Sixth Circuit, which came out in 2020 after the Armstrong case. The reason why that case is instructive is because it provides an excessive force analysis where law enforcement officers released a canine on a non-compliant individual acting under suspicious circumstances, who the court deemed an unknown quantity, arguing with the officers, waving her hands around, refusing to face away from the officers. Now, officers in that case didn't know whether she was armed or not. There was no report that the plaintiff was armed. Here, we have knowledge from Putman himself, Putman's own words to his wife, or at least that's what we believe based on the wife's statements, that Putman said that he was armed with a gun and was going to use it to kill himself.
The difference in the Sixth Circuit case, though, and maybe it doesn't make a difference, is that that individual was considered to be a criminal suspect, right?
Your Honor, the plaintiff's boyfriend was a criminal suspect.
But wasn't she part of that? I mean, they had some indication that she might have been involved as well.
She was in the vehicle that he was driving. I don't believe the court made any reference to her being a suspect at all. Her boyfriend certainly was a suspect in the armed robbery. That's true. But the court had the officers in that case had no information that the individual that was stopped. So the boyfriend fled in that case prior to the car being stopped. The officers had no information that she was a danger at all until she essentially got out of the car and did a whole bunch of things like Mr. Putman did to show that she could be a threat. And I see I'm out of time, Your Honors. We ask that you reverse the ruling of district court and award qualified immunity to the officer. Thank you, Your Honors.
All right, thank you very much. Want to thank you both for your arguments, and we are sorry we can't come down and greet you, but I think you understand the reasons. And let's proceed into our next case.
Thank you.
3rd. The question before us today is one of statutory interpretation. Does the PLRA require plaintiffs with disabilities to exhaust both the internal prison grievance procedure and a second external remedial process applicable only to plaintiffs with disabilities? The answer is straightforward. The PLRA only requires exhaustion of internal prison grievance procedures. And that answer is particularly apparent here and under Jones, where the BOP grievance policy says nothing about this second external EEO process. And it is even more apparent because the BOP's grievance procedure itself describes the last step in that procedure as the, quote, final administrative appeal. And it is also apparent when construing the PLRA consistently with federal disability rights laws, as this court must. Requiring plaintiffs with disabilities to engage in a different and unequal process prior to enforcing their rights in federal court.
What do you mean by unequal? It's just another avenue toward getting redress and a remedy would seem to be beneficial, not necessarily detrimental.
Well, Your Honor, it requires plaintiffs with disabilities to engage in an additional process.
Well, it requires every person, not disabilities or otherwise, right?
No, Your Honor. This EEO procedure is argued to apply only to prisoners who are bringing claims under the Rehabilitation Act.
Are you aware of any other external remedies available to just prisoners without disabilities, just as a matter of course?
No, Your Honor, I am not aware of any prison officials, and my colleague on the other side have not pointed to any other external procedures that are required for any other types of claims.
So just so I understand your argument, it doesn't matter. You mentioned at the very beginning of your argument that the program statement itself made it clear that finality had been reached once your client complied with the traditional internal remedies procedure. But even if the program statement had been more explicit about this external remedy, your view is that your client can't be forced to abide by that or complete it.
If the BOP grievance procedure had included a specific reference to the EEO policy,
Right.
I do think that they may resolve the threshold question under Jones on whether it could be required under the PLRA, but it would not resolve the conflict with the Rehabilitation Act itself, because it would still be requiring plaintiffs with disabilities and only plaintiffs with disabilities to engage in this onerous second process that takes more than an additional year to complete beyond the BOP's grievance procedure itself, requires engaging with a second external agency, and may require an evidentiary hearing before an administrative law judge.
Why isn't the test here exhaustion is linked to an available remedy? And there's no question, is there, that the EEO remedy is available. It's spelled out at length in 28 CFR 39.170. There's no question that it's available, is there?
Well, Your Honor, there is a question on availability here. In fact, the EEO process was not available to Mr. Williams because prison officials had not informed him of its existence. It is undisputed that there is no reference to the EEO process in the BOP's grievance policy. And my colleagues on the other side have put in no evidence that Mr. Williams was otherwise informed of this additional procedure. So under
I'm not aware, though, that they were required to inform him. I mean, there are all sorts of statutes and regulations and everything that may govern prison behavior, but the prison authorities are not required to inform someone of all of those things. The question is it available? And there's no contention, as I understand it, that the prison officials misled the prisoner or tried to hide or mislead the prisoner about the availability of this procedure?
Well, Your Honor, actually, under the case law, because the PLRA, of course, by its own terms, only requires exhaustion of available administrative remedies. And courts have interpreted that to require it to put an affirmative obligation on prison officials to inform prisoners of administrative remedies. If they do not meet that affirmative obligation, remedies are not available. So, for example, the Seventh Circuit in Ramirez considered a case where a prisoner spoke only Spanish and the prison grievance procedure was only available in English. And there, the court held that remedies were not available because they had not been made known to the plaintiff in a language he could understand. Similarly, the 11th Circuit in Gobert, which I think is quite on point here, looked at a situation where the grievance requirements were spelled out in two separate policies, and the plaintiff was only provided one of those policies. She complied with the requirements in that policy, and when the prison officials came back and said, but wait, there's a second policy and you did not comply with the procedures in that policy, the court held that those remedies were unavailable because the prison officials had not made that second policy available to the plaintiff. They had not provided it to her to make it known. And that is exactly what we...
In terms of making it known, prisons have considerable assistance. Couldn't the individual have gone to the prison librarian here? The prison librarian could have explained the procedures pretty thoroughly. It seems odd to me when you look at this EEO procedure, it's spelled out in great detail. It seems odd that they would go to the trouble of setting forth a remedy in great detail about when the hearing has to be held and how long after the complaint is filed and everything. If that was unavailable, it's spelled out in great detail, and the prison officials did nothing to prevent or impede this individual from utilizing the procedure. And if that's the case, it was available.
Oh, Your Honor, I'd like to make a couple of points in response. First, to be unavailable, there is no requirement that officials affirmatively impede or mislead or act untoward in any way. It is enough that they did not make the procedure known. And it's also, there is no affirmative obligation on prisoners to conduct exhaustive legal research using...
Well, the BOP did issue a program statement, did it not, in which it was known?
I'm sorry, Your Honor, I think I missed the last piece of your question.
The BOP issued a program statement in which it was known.
Your Honor, the BOP grievance procedure itself contains no reference to the EEO process, and that is undisputed. And now there is a second policy that was not before the district court, but that my colleagues on the other side presented for the first time on appeal. And under this court's usual proceedings should not be considered. But even if considering that second policy, it still does not make remedies available because there is no evidence in the record that Mr. Williams had access to the second policy, just as in Gobert and the 11th Circuit's announcement.
No, there's no evidence that he didn't have access, and it's there's no evidence that he didn't have access. There's no evidence that he could not utilize the procedure.
Well, Your Honor, failure to exhaust is an affirmative defense that the defendants must plead and prove. And to meet their burden, they must demonstrate first that there was an available administrative remedy to the plaintiff and that the plaintiff failed to exhaust it. Here, they have put no evidence in the record that this procedure was available to Mr. Williams. So the prison officials here have not met their burden of this affirmative defense of
But you have put no, but on conversely, I'm not sure you put forward any evidence that it was not available. One of the things that this PLRA was intended to do was to reduce this kind of prison litigation, these sorts of prison litigation lawsuits. And in order to do that, an exhaustion of administrative remedies was a critical component of what the PLRA was trying to accomplish. And the scheme is not redundant in any way. The BOP administrative remedies were internal remedies that allow the BOP to conduct a review of its procedures and to correct its own mistake. The EEO remedy is a different remedy because it allows an external administrative agency to look at what's going on in the BOP. And the EEO has expertise in this area. It is the kind of agency, it is an agency that is accustomed to applying on a regular and consistent basis the Rehabilitation Act and applying it. And so you have an administrative scheme here that is not redundant, that is not repetitive, and that seems to fit with Congress's overall purpose of having agencies take a look at that before going into federal court. In fact, there are a slew of district court decisions that hold that the EEO remedy is an available remedy, a long line of district court decisions. And I worry that we are dumping a great deal of work on federal district courts that could be resolved by the agency itself. And so the consequences of this are quite far-reaching, and it makes sense as a coherent whole to have these two non-redundant procedures available for use to the inmate.
Well, Your Honor, the PLRA, as you noted, was intended to allow prison officials to correct their own mistakes internally and to resolve claims efficiently. However, that is what the BOP grievance process itself is for. The DOJ EEO process is not necessary and does not meet those goals. Rather than keeping the issue internally, it takes the issue out of the hands of prison officials.
Does it matter that the BOP is part of the Department of Justice? And so an argument could be made that it, in fact, is internal.
Your Honor, I don't think it matters that they're both part of the DOJ. It's still taking the issue out of the hands of the BOP prison officials and putting it in front of an administrative law judge. And further, the BOP grievance policy itself is considered sufficient to meet the goals of the PLRA for all other types of claims. We've heard no justification for why disability claims and disability claims alone require this second onerous procedure.
Where does the statute say available internal remedies? You are adding a term to the statute. The statute talks in terms of available administrative remedies. The statute does not make a sharp distinction between internal remedies and external remedies. And even if it did, which it does not, the EEO remedy, as Judge Diaz noted, could be seen as internal because the EEO is, after all, a part of the Department of Justice. But the basic point here is that the statute doesn't say available internal remedies or draw a distinction between the internal and the external. So where do we get the authority to write this gloss on the legislation?
Yes, Your Honor. Well, first, the Supreme Court in Woodford held that it is the prison's grievance policy requirements itself that govern proper exhaustion and not the PLRA. And in Jones, the court was unequivocal. It said, quote, compliance with prison grievance procedures, therefore, is all that is required by the PLRA to properly exhaust. And this interpretation is confirmed by the legislative history that demonstrates that when Congress used the term administrative remedies, which is an undefined term, it meant internal prison grievance procedures.
Where does the statute use the word internal administrative remedies? And if you want to look at the legislative history, what Congress was trying to do was to curb all of these lawsuits that are coming in and put some sort of break on them. And exhaustion is critical to what Congress wished to accomplish. If Congress had used the word available BOP remedies, that would help your case substantially. If Congress had used the word available internal remedies, that would help your case substantially. But those are simply not the terms that Congress used.
Your Honor, I think that's why we need to look at Jones, which was unequivocal, that it is the prison grievance procedures itself that govern. And further, again, the BOP already has a grievance policy in place to meet the goals of the PLRA. And I see I'm at my time, if I could just finish.
Well, let me just, well, we can talk about Jones here for a minute. If you read that decision, it emphasizes the need to stem frivolous suits and to do so expeditiously, which often, and then Jones says expedition is not always available in federal court. I'm not sure why you think Jones helps you in that regard. And also we're dealing with remedies where a failure to exhaust, it doesn't throw you out, it simply dismisses without prejudice. You go by and do the administrative remedy, and who knows? You may well win. I don't know. But you've got an agency whose job it is to apply the RA, and you may well win.
Your Honor, I'm over my time.
No, I've taken up some of your time, and I apologize for that. So I'd like to hear what you have to say.
Yes, Your Honor, thank you. So I do think Jones is directly applicable here because it was rejecting the imposition of a requirement onto the grievance procedure that was not found in the prison's grievance policy itself. And that is the same situation we have here. There is no mention of the EEO process in the BOP grievance procedure, and therefore under Jones, it is not required to be exhausted under the PLRA. And again, we need to read the PLRA consistently with the Rehabilitation Act, and that is another critical component of the statutory analysis here. The requiring exhaustion of this EEO process only of plaintiffs with disabilities raises serious conflicts with federal disability rights laws, and the PLRA cannot be read to conflict with those federal disability rights laws.
Can I ask, before you sit down, one question? So at the beginning of your argument, you made a point that I want to follow up on. Let's assume for the moment that we don't agree with you and conclude that this was a proper internal remedy that your client had to exhaust. At the beginning of your argument, you appeared to suggest that in terms of availability, the remedy was not available because prison officials did not explicitly direct him to the remedy. In fact, suggested that he had exhausted. So what in the record suggests that?
Your Honor, the district court made a finding, and I believe it's undisputed, that the BOP grievance policy itself says nothing about this EEO procedure. And there is no evidence in the record that the EEO procedure was made known to Mr. Williams through any other means. And again, because failure to exhaust is an affirmative defense, it is defendant's obligation to prove that this remedy was available to Mr. Williams.
Okay, just so I'm clear, but there's nothing in the record that says, oh, by the way, Mr. Williams, you're done as far as remedies are concerned once he exhausted with the BOP. There's nothing like that.
Well, I think there is, in fact, because the BOP policy itself, laying out the procedure, says that the final step in the procedure is the quote, final administrative appeal. Any reasonable person reading that language would say, I have completed the full BOP procedure. I have completed my final administrative appeal. I have done all that is required under the PLRA.
Okay, thank you.
All right, counsel, Ms. Petrosi, let's hear from you.
Good morning, Your Honors, and may it please the court. My name is Holly Protesi, and I represent former Bureau of Prisons Director Michael Carbajal. Mr. Carbajal asked this court to affirm the district court's decision in its entirety. Your Honors, the Prison Litigation Reform Act is as plain as it is mandatory. Before any prisoner may bring a lawsuit pursuant to any federal law, he must first exhaust all available administrative remedies. Here, in order to seek relief under the Rehabilitation Act, Mr. Williams was therefore required to exhaust not only the Bureau of Prisons administrative grievance procedure, but also the publicly available and specialized Department of Justice EEO compliance procedures found in Part 39 of 28 of the Code of Federal Regulations. The district court here properly dismissed Mr. Williams' Rehabilitation Act claim without prejudice for failure to exhaust both available administrative remedy procedures before he filed suit. Your Honors, Mr. Carbajal does not dispute that Mr. Williams exhausted the BOP's administrative remedy procedure generally to challenge the disciplinary sanctions he received after an incident report. But Mr. Williams did not utilize the Department of Justice administrative remedy procedures to present the agency with notice of his alleged discrimination and retaliation claims. The purpose of administrative exhaustion is not to create unnecessary procedural hurdles on the path to federal court. The purpose is to create an additional step towards the finish line. And the finish line is not necessarily litigation. The finish line is resolving the claim. Here, Your Honors, again, the purpose of administrative exhaustion is to give an agency an opportunity to correct its own mistakes and also to promote efficiency. Both of those goals can be accomplished here through the Department of Justice procedures.
Except that the agency here is not being asked to correct its own mistakes. It's suggesting or requiring the prisoner to go to another agency for correction of the BOP's mistakes.
Yes, Your Honor. The prisoner would then be required to go to the Department of Justice, but the Department of Justice is a parent agency of which the BOP is a component part. And the Department of Justice can require the Bureau of Prisons to take action. The compliance procedures found in Part 39 of Title 28 of the Code of Federal Regulations indicate that Bureau of Prisons staff can be required to participate in the investigation, and if any violations are found, a remedy can be imposed by the Department of Justice on the Bureau of Prisons so that the Bureau of Prisons can actually remedy the situation at hand in the prison.
So let me ask you about the issue of availability. At the very end of the exchange with your colleague on the other side, I asked her, assuming that we hold against her client and find that this remedy is in fact a proper internal administrative remedy that needed to be exhausted, she pointed to the fact that the program statement all but suggests that as far as Mr. Williams was concerned, that he was done, that he didn't need to do anything else with respect to this exhaustion. What is your response to that?
Yes, Your Honor. The Bureau of Prisons Administrative Remedy Procedure Program statement itself does not reference the EEO procedures. That is undisputed. However, there are other program statements that are promulgated by the Bureau of Prisons that do reference this.
I don't think there's any dispute about that. The question is whether that program statement that is most relevant to exhaustion misled Mr. Williams to believe that he was done and his next stop was federal court.
Your Honor, the program statement needs to be read in light of the facts at issue here and the grievances that Mr. Williams specifically filed. The grievances Mr. Williams filed challenged the disciplinary sanctions he received. He indicated that he received a disciplinary report for failure to obey an order, and he was challenging that sanction and asking that it be expunged. Nowhere in these remedies did he alert the BOP to the fact that he was alleging wrongful discrimination or retaliation. Had he done so, then it may have been incumbent upon the BOP to alert Mr. Williams that there was another process, but he did not. There was no evidence in the record, Your Honors, that the Bureau of Prisons was on notice that the specific actions Mr. Williams was challenging was improper, discriminatory, or
So
retaliatory
when
conduct.
do you say that first came up?
Can you repeat your question, Your Honor?
Sure. When do you say that the issue of discrimination and disability first came up?
When Mr. Williams filed his action in federal court, Your Honor.
So is there a waiver argument?
There could be, Your Honors, yes. Mr. Williams did not present the notice to the BOP that this was the issue he was claiming. And Your Honors, part of the purpose of administrative exhaustion is to give the agency that notice. Your Honors, more to
One of the questions I have is how far the agencies and everything must go in giving notice. And we have all kinds of litigation before us, which is governed by legal regulations, statutes, case law, treatises, and I don't think we've ever said that the government has an obligation to notify the inmate of this and that and the rest. And there's a reason for that, because the more you require notice of this, notice of that, notice of this legal requirement, notice of that legal requirement, you're almost having the government act as a party to the case and a sort of lawyer for the inmate. Most of these prison environments, the inmates are pretty aware of what they need to do. It's quite a grapevine. I just worry about what kind of path we're leading if we say you have to notify this and this and this that might be of use to an inmate in a legal proceeding. I don't understand the limiting principle there. But my basic point is that this question is not a question of notice, it's a question of statutory interpretation. And maybe Congress got it wrong. It's clear what Congress was trying to do, but if Congress got it wrong, all Congress needs to do is add the word internal or add the word BOP or whatever. But Congress didn't do that. It wanted all available. And why did it want all available? An exhaustion of all available remedies, because it was trying to stem what was a flood of prison conditions litigation in federal court. But there's an easy legislative fix to this if that's what Congress in its wisdom decides it wants to undertake. You see my point about the wording of the statute?
Yes, Your Honor, absolutely. The wording of the statute does not include any reference to internal remedies or even just specifically prison remedies. The only indication in the statute, and the Supreme Court has found that the only limitation in the statute is whether administrative remedies are available. And I think, Your Honors, there is a distinction in availability as well. The first step is whether an administrative remedy procedure is generally available. And in this case, the EEO procedures are generally available in the Code of Federal Regulations. They're publicly available and they are specialized. The next question could be whether they are specifically available to an individual person. And that would be where the facts are utilized in that case. And I think, Your
And
Honor,
the other thing is the prisoner is gonna be notified of this very quickly, because what the federal court will do is dismiss quickly without prejudice. And the reason for the dismissal without prejudice is so that the inmate can exhaust the available remedy before the EEOC. And so you're going to get that notice. That's notice. You've got to go and exhaust this remedy before the EEOC and come into federal court. So one way or another, it's going to be, the notice is going to be provided the inmate, and it's going to be, there's going to be no prejudice here, because these exhaustion dismissals are invariably without prejudice. And that is the notice. Go back. If you're probably going to know this on the front end, because there are many inmates who do exhaust that remedy. And even if you don't know something on the front end, the district court will have a quick dismissal without prejudice, and you will go and exhaust the remedy, and it won't hurt the inmate one single bit.
yes, Your Honor, absolutely. In this case, the district court did dismiss this case without prejudice. And Your Honors, even if Mr. Williams' time to file with the EEO had elapsed, the compliance procedures do allow for an extension in that time period for good cause shown.
Well, I'm glad you raised that, because I think there is a concern here about the time frame having been run with respect to the ability of this particular inmate to file a complaint. You know if that's true?
Your Honors, he received his final response from the General Counsel of the BOP on January 27th, 2020. And when he filed his complaint, that was in May of 2020. But Your Honor is correct that the district court denial of his motion for reconsideration and granting of the motion to dismiss was not until March of 2022. Of course, if for any reason he submitted a complaint to the Department of Justice today, and the Department of Justice rejected that remedy as untimely, and he was unable at that point to utilize the procedure, that very well may be a case specifically relevant to Mr. Williams, where the remedy procedure was unavailable. But it doesn't mean that it was unavailable at the time he filed the suit, and it doesn't mean that it's generally unavailable.
Well, it may be that the timeliness is told while the case is in federal court before it's dismissed without prejudice. That might toll any kind of time limitations. But one thing that concerns me is the EEO is the federal agency with the most expertise in this kind of prison litigation. It looks at these cases nationwide, and it has built up through the years a considerable experience and expertise with these cases. And it just seems unusual to me that we would cut out the agency whose experience can best be brought to bear and say that Congress in a statute meant to curb this kind of legislation actually meant to cut out and render nugatory the administrative agency and the administrative remedy, which could have brought the greatest background and experience to the claim. It doesn't make sense to me in light of the wording of the statute to say that this is not available when the remedy is the very thing that would be most constructively and informally brought to bear on this gentleman's claim. And who knows, many times people receive relief, many times there's conciliation, many times there's a settlement, and it would be best to have this done without without going into federal court, but there's an easy legislative fix here, and the reason the legislative fix has not been applied was. Please proceed.
I apologize, Your Honor, you cut out a bit at the end. So if I missed any part of a question in there, please let me know. But Your Honor, I think you bring up a great point in that the Department of Justice, the EEO, has expertise in these Rehabilitation Act claims that the BOP itself may lack. It doesn't have this specialized knowledge that the DOJ has, that the EEO has to resolve these complaints. And it allows for informal resolution. It allows for a factual record to be developed. That factual record can be appealed to the complaint adjudication officer. And if either party were to request it, an administrative law judge can also hold a hearing. And if ultimately this case were to make it to federal court, the federal district court would have an administrative record to rely on that may narrow the facts, may narrow the issues, or otherwise present a complete record for review.
The other thing is, this is not an agency which is unsympathetic to civil rights claims. The EEO validates the position of petitioners and plaintiffs in many cases, and rightly so. And the case is resolved to plaintiffs' benefit and satisfaction without going into trying ab initio, essentially, the case in federal district court. It's not an unsympathetic forum. We're not banishing somebody to something where there is no hope of redress.
Absolutely, Your Honor. And Judge Diaz, did you have a question?
So your colleague on the other side talked about and I know I think you sort of answered the question with the most recent comment, but she makes an argument that in fact this is discriminatory because one set of prisoners have to go through an additional layer of review. Counter is that this actually might be salutary because it provides yet another opportunity to remedy whatever the complaint is. But I guess at some point, there might be so many layers of administrative review that one could argue that the prison is in fact attempting to exhaust the prisoner by preventing him from getting to federal court. I imagine you don't think that's the case here, but what about the concern about disparate treatment involving two different sets of inmates?
Of course, Your Honor. The BOP's general administrative remedy procedure does apply to all inmates. The EEO procedure only applies to inmates alleging discrimination or retaliation on the basis of a disability. So here, there is a prisoner who falls into two categories. He is not only an incarcerated individual, but he is a disabled individual. So if he wishes to vindicate only the rights of a general prisoner, then he would have to exhaust the BOP's administrative remedy procedure. And in fact, he had claims that only needed to be exhausted at the BOP level. He brought claims under Bivens, and he brought claims under and he brought injunctive relief claims. The claims he specifically brought under the Rehabilitation Act, then he had to utilize the EEO procedures because those procedures were specifically implemented to enforce the rights under the Rehabilitation Act.
And those are the claims you say that he didn't actually raise until he got to federal court.
Correct, Your Honor. Not with any specificity. Your Honors, does the court have any additional questions?
No, I don't. If my colleagues have questions, I'd be delighted to have them ask them. If they don't, we would thank you for your argument.
Thank you, Your Honors. Mr. Carbajal respectfully asks that this court affirm the decision of the district court in its entirety.
Ms. Whitaker, you have some time reserved for rebuttal, and we'd be pleased to hear from you.
Yes, thank you, Your Honor. I'd like to start just by correcting correcting the factual record here. Mr. Williams did in fact raise his disability discrimination concerns in his grievances to the BOP. In fact, he even cited to the Americans with Disabilities Act. And that grievance and citation can be found on Joint Appendix page 79. And I also wanted to address the discussion around the expertise of the EEO process. And I'll note that a ruling that the PLRA does not require exhaustion of the EEO process does not preclude plaintiffs from taking advantage of it. Now, of course, the Rehabilitation Act itself does not contain an exhaustion requirement. Plaintiffs bringing claims under the Rehabilitation Act are not required to exhaust the EEO process. It is voluntary by its own terms. In fact, the language of the regulation uses the word may. So the only exhaustion requirement at issue here is that of the PLRA. And once a prisoner has met the requirements of the PLRA by completing the BOP grievance procedure, they then may choose to either pursue their claims through the EEO, or they may choose to pursue their claims in federal court. And I'll also note that these are, of course, policy considerations rather than ones of statutory interpretation. And when we go back to the language of the statute and look at what other courts of appeals have considered when looking at the language here, both the Ninth and the Third Circuits have held that the PLRA's exhaustion language refers to internal prison grievance procedures. The Ninth Circuit in Rumbles looked at this language and determined that only internal prison grievance procedures must be exhausted. It rejected the argument that prisoners must also pursue an external remedy through state tort procedures.
How does this some kind of discrimination, or it can also be seen as an opportunity that an administrative remedy is made available? I am nervous about the idea that anytime an administrative remedy is provided to a particular class of plaintiffs, that is a discriminatory action. I don't think the Supreme Court would buy off on anything like that. It's just as easy to say that providing an available remedy to one class of plaintiffs and not to another is making an opportunity available. I don't necessarily disagree with your policy arguments. It may be that they should be able to bypass the EEO with its background and expertise, but all I want is a statute that puts in either any of the things we have been discussing today, the word internal, the word BOP, just something. All it requires is an adjective to get to your view. There's the bridge, an adjective that is not there. Do you see my point?
I do.
Probably
Once again, I'm over time.
Yeah, I've taken up a lot of your time, and I want you to have some extra time until you feel like you've made your case. Okay?
Thank you, Your Honor. And I share in your frustration, as other courts have, that the PLRA, as the Second Circuit said, is not a paragon of clarity. Congress could have done more to make this more explicit, but that's where we need to look at how the Supreme Court has interpreted and applied this provision. And of course, the Supreme Court's decisions in Woodford and Jones, where it held that it is the prison's internal grievance requirements that govern, and that compliance with the prison's grievance procedure is all that is required under the PLRA. Those determinations are binding on us here. And because the EEO
Okay, but also sometimes prisons make mistakes. You and I can find some agreement and common ground there. Prisons and prison bureaucracies are not infallible. And sometimes, goodness knows, they make mistakes. And that's one of the reasons the EEO is there, is to correct the mistakes that they make. And it seems to me quite inventive in one sense for Congress to provide a corrective mechanism within the executive branch for mistakes, and not just leave the BOP to its own devices. But I am concerned about, there are just a whole lot of ways in which the EEO can provide district courts a great deal of assistance with a record and all kinds of other things. And I'm just not sure that the question before us, I do not think you keep relying on the Jones decision, but I do not think that this question was in Jones, and a great many courts have held that exhaustion is required, a great many. But go ahead.
Yes, Your Honor, and you were cutting out a little bit there, so I apologize if I missed something. But to the beginning of what you were getting at there, the BOP grievance policy is what provides prison officials the opportunity to correct their own mistakes. And that procedure is sufficient for all other types of claims. There's simply no reason why disability claims and disability claims alone must be sent through this second onerous process that can take more than a year to complete. And further, these other district court cases that Judge Wilkinson referenced, frankly, got it wrong. They all seem to assume that because the EEO process exists and because the BOP says so, it must therefore be required. But that is not what the law holds. Jones, I believe, is directly applicable here. It said that only those requirements set out in a prison's grievance policy must be exhausted under the PLRA.
What if the prison in this case had said, with respect to discrimination claims, we're not going to have any internal administrative remedy in the BOP, but you need to go directly to the EEO? Would that be okay?
Your Honor, I still think that would be problematic when trying to construe the PLRA consistently with federal disability rights laws. If the BOP wanted to bring in additional disability rights expertise, they could certainly do so as part of the standard BOP grievance procedure. They could have people with disability rights expertise review those grievances. But to be consistent with federal disability rights laws, prisoners with disabilities must be given equal access to the grievance procedure. They must not be required to engage in that service in a different or unequal way. That is what
the council, that's for Congress to decide. That's not for us to decide. You're making a policy argument, and this discussion has been constructive in this sense. Your position is not one, and I think that Judge Diaz was indicating this. Your position is not one that he didn't get notice of the EEO procedure. Your position that even if he had gotten notice, the requirement would still have been extraneous and burdensome, whether you get notice of it or not. Your position is not dependent on fairness or notice, because you say this is impermissible, that it's discriminatory, which that position has all kinds of problems. But your position goes far beyond notice. And what you're saying is that this is intrinsically impermissible for Congress to have done.
Well, Your Honor, I'll note that Congress did not do this. They did not require the EEO process. Congress required that prisoners exhaust such administrative remedies as are available. And all we need to do here is interpret that language consistently with federal disability rights laws. Congress did not mandate through the EEO procedure that prisoners exhaust that set of procedures. There's nothing in the language of the EEO procedure itself that makes it mandatory on prisoners. So I can misunderstand what you're saying there, but I did just want to note that.
No, that's fine. But it's really a simple case at heart. Congress mandated the exhaustion of available administrative remedies. This remedy is available. This remedy was not exhausted. It is a very simple syllogism, and it has at its heart a fidelity to the legislative text and say, okay, Congress, this may be a problem, please fix it. But at any rate, we need to conclude this, and I give you the last word. Tell me why everything I said to you is woefully incorrect.
Well, Your Honor, as the last word, I will just note to what you just said about available. There is no evidence in the record here that this remedy was available to Mr. Williams. My colleagues on the other side have pointed to no evidence that made this remedy available. And the PLRA simply does not require it when interpreted consistently with federal disability rights laws and when following the binding precedent of Jones. So, Your Honor, we ask that this court reverse the district court's grant of summary judgment and remand for further proceedings on the merits.
All right, well, I want to thank you for a very constructive and interesting argument. Both you and government counsel have done a fine job, and I just want you to know how appreciative I am. Thank you both.
Thank you, Your Honor. Thank you.
We'll move into our next case.
May I begin, Your Honor?
Please proceed.
Morning, Your Honors. May it please the court. My name is Richard Cuthbert, and I represent the appellant, Ms. Faith Dennis. Ms. Dennis was diagnosed with lupus at age 14. She was 25 at the time of her hearing in this case. And at that time, the ALJ found her to have several impairments, including lupus, avascular necrosis of the ankles, fibromyalgia, stage 3 kidney disease, joint dysfunction, anemia, peripheral vascular disease, and borderline intellectual function. The only successful treatment of her lupus flares was long courses of prescribed prednisone. However, the prednisone itself became a problem, causing the avascular necrosis of her bones. Her treating rheumatologist at VCU, Dr. Nandon, supported her claim and opined that there were no good treatment options for her condition. The record shows that Dennis had 17 specialist appointments at VCU during the work week in the 22 months between the alleged onset date and the hearing date. The record also shows that Dennis had 14 unscheduled days at a hospital facility in those 22 months. This objectively totals to more than 12 days per year receiving medical treatment during the period at issue. The VE in this case testified that missing more than 7 to 10 days of work per year eliminates work at the unskilled level. And I argued both before and during the hearing that absenteeism would eliminate Dennis's ability to perform SGA. That can be found in the record at AR 65 and 297. However, the ALJ didn't even address absenteeism in the denial, and despite the record, determined that Dennis could maintain employment without missing any work due to absenteeism. So that leads to the key question in this case. Did the law require the ALJ to address absenteeism in the denial in the context of the facts of this case? And the answer is, of course, yes. That's bedrock principle of appellate law. The commissioner must consider all the evidence and explain on the record the reasons for her findings, including the reasons for rejecting relevant evidence. A necessary predicate to engaging in a substantial evidence review is a record for the basis of that ruling. And here, the ALJ failed to address absenteeism in a way that allows this court any meaningful review. The ALJ gave no explanation, provided no basis for dismissing absenteeism in the denial. The ALJ didn't address the claimant's arguments that absenteeism would rule out work. The ALJ didn't address the VE's testimony that missing 7 to 10 days of work per year would eliminate work. No mention that scheduled appointments were unnecessary or could easily be scheduled around employment.
Counsel,
Yes,
when you've got an ALJ and the appeals council and the district court all denying the claim.
Yes, Your Honor.
And to get a reversal after this string of denials, something would have had to have gone pretty wrong. And looking at the record as a whole here, let me just identify what I think are some of your obstacles. The vocational expert identified a large number of jobs that your client could have held with restrictions, but they were still sedentary jobs. There was no evidence, as I understand it, that your client had actually sought work. Your client did have an associate degree from high school, but there was no evidence that she was dismissed from any job because of partial absenteeism, or that her appointments with occasional specialists rendered her unemployable in some way. But given the fact that the vocational expert, now let me boil it down, given the fact that the vocational expert has said that there are a large number of sedentary jobs she could hold, and given the fact that she has never sought work or never sought out those jobs that the vocational expert said she could hold, what are we supposed to do with that?
Yes, Your Honor. Well, the way that the ALJ got to that evidence is the ALJ relied on a hypothetical that didn't consider all the facts. Certainly, if the ALJ is allowed to cherry pick or ignore relevant evidence, then we can say substantial evidence supported the ALJ's decision. But here, there was evidence that both scheduled and unscheduled treatment rose above the minimum threshold that the VE set forth that would eliminate work. So the VE said that missing 7 to 10 days of work per year would eliminate work. That's a little bit over a half a day a month. And if you look at the record, even if Ms. Dennis were to miss only a half a day for these this treatment at VCU, it would rise above that minimum threshold.
So,
So
Mr. Cooper, just so I understand your point is that when the VE vocational expert said that there were jobs in the economy that your client could do, he or she did not take into account the issue of absenteeism because the ALJ didn't prod that as part of the hypothetical.
well, somewhat. So hypothetical 3, the ALJ lists a bunch of criteria, limitations, but doesn't include absenteeism. And the VE says, well, yeah, if you don't have these
Sure,
limitations, you can work.
Right.
And then the ALJ follows up with another question. And the ALJ says, well, what if the hypothetical claimant were to miss 1 day of work or more? And there the VE says, well, that will eliminate work. And the ALJ at that point was stuck, right? Because usually the
Right,
ALJ
and the
was,
problem is the ALJ didn't reconcile that conflict.
they didn't just ignored that. And it's very much just like in Kreider versus Harris, where Kreider versus Harris was a case where this court reversed. And there, the ALJ posed a hypothetical question to the VE about vision. And the VE said that it would eliminate work. And the ALJ just ignored it in the denial. And then that case went up on appeal. And this court in 1989 said that the response of the vocational expert confirmed that Kreider could not perform SGA, that no allusion is made to the critical hypothetical question, and answer is a strong indication that no reference was found possible, which would permit any conclusion other than that Kreider should be awarded benefits he sought. And that's exactly what happened here, right? Well, we made the argument before the hearing. In my pre-hearing brief, we made the argument at the hearing that absenteeism would eliminate work. And the ALJ just ignored the issue, and the ALJ ignored the issue because it was dispositive. If the ALJ found that Ms. Dennis was going to miss work treating more than essentially half a day a month, according to the vocational testimony, she would have been found unemployable.
So the district court in this case, and I know we reviewed this case de novo, but said that looking at the record in this case, that the sole expert that would support a finding of absenteeism didn't really explain why. Dr. Nadden's medical opinion indicated, well, there is an issue of absenteeism here, but left the explanation block blank. What are we to do with that?
Well, that was misleading somewhat because Dr. Nanden, the ALJ addressed Dr. Nanden's opinions at AR 25. So the word absenteeism does appear twice in the denial. Once at AR 25, when the ALJ talks about the 16 opinions of Dr. Nanden and lumps them all together and starts with the claimant has chronic lower extremity pain. This is Dr. Nanden. Due to avascular bone necrosis, lupus, is unable to perform activities of daily living, would be unable to work even if the job were sedentary, would be absent, there it is, as a result of her impairments or treatment twice a month, would be off task, is unable to get through. And it goes on for 16 opinions. And the ALJ just dismisses all of those opinions in the 4 sentences that follow. And it does in that last 4th sentence, the ALJ says something like, I'm dismissing these opinions because it's just a Circle 4 form. But the Circle 4 form was really only addressing listing 14.02 regarding lupus. It had nothing, the judge wasn't talking about the opinions found at 762 that contained the bulk of those opinions that the ALJ just dismissed. So I don't think the ALJ actually addressed absenteeism at all in the denial, despite what opposing counsel insinuates. Thank you.
All right, we thank you. I'll ask my colleagues if they have any further questions of you. Either of you have any further questions? Okay. All right, well, let's hear from the other side here.
Good morning, Your Honors, and may it please the court. My name is John Lucier. I'm from the U.S. Attorney's Office here in Richmond, and I'm representing the appellee, the Commissioner of Social Security. Your Honors, routine health management, even for a chronic condition, is not in itself incompatible with substantial gainful activity, and thus is not automatically disabling under the Social Security Act. Instead, a Social Security claimant bears the burden to prove that her routine medical treatment would actually cause work absence sufficient to preclude work. Here, Dennis provided no evidence that her treatment was work preclusive. Her evidence, which is the existence of medical treatment during the relevant period, is insufficient by itself without further evidence that it would require her to be gone from work, to be absent from work. She did not offer testimony, other forms of evidence that she could not fit her regularly scheduled appointments around her work schedule, or that there were sufficient number of unexpected appointments to make her treatment work preclusive. The ALJ reviewed Dennis's medical records in their entirety for the entirety of the relevant period, which is March of 17 to March of 19, reviewed her inpatient treatment in July of 2018, reviewed the opinion of her rheumatologist, Dr. Nandan, who said that she would be absent from work more than twice a month, and found that the record showed that she could sustain full-time, unskilled, light work activity with a series of limitations that were set forth in the residual functional.
So can I ask about the VE opinions and those various hypotheticals? So with respect to the one about absenteeism, where the vocational expert, based on the hypothetical presented by the ALJ, said that Ms. Dennis could not engage in substantial work activity. So what's your view of that? I mean, is your view that the evidence doesn't support the hypothetical, or what is it? Because it seems to me that having made the point about absenteeism, the ALJ at a minimum should have addressed that in his or her, I don't know if it's he or her, decision. And it doesn't appear that he or she did.
Well, 2 points in response to that, Your Honor. First is the role of the VE in the hypothetical. An ALJ can ask 2, 3, 4, however many hypotheticals to the VE as an ALJ thinks is appropriate at the hearing. There were 4 here, the third of which contain the limitations for, the fourth of which, the third was the one adopted by the ALJ. The fourth hypothetical contained the question from the ALJ, well, what about if this person is absent for a certain number of days? The VE responded to that hypothetical. It's up to the ALJ, and it is the ALJ's factual finding which hypothetical the ALJ ultimately adopts, and also which hypothetical ultimately reflects the limitations that the ALJ finds are appropriate at the RFC in step 4. So that's for purposes of the VE's hypothetical in and of itself. The other the other significance of that is that it does show that the ALJ in fact did consider absenteeism at the hearing, and also considered it at in the decision that the ALJ.
So can you point me to where in the ALJ's decision that the judge rejected the factual basis for that fourth hypothetical?
The ALJ, we know that the ALJ addressed absenteeism in the decision because the ALJ reviewed the existence of the treatment, reviewed all of the treatment, reviewed the inpatient treatment, specifically rejected the opinion of Dr. Nandan, which specifically had an absenteeism opinion in it, accepted the opinions of the 2 state agency physicians.
Rejected on the grounds that the evidence didn't support absenteeism, or for some other reason?
Rejected on the grounds, rejected is the ALJ found it not persuasive. Dr. Nandan's opinion not persuasive, so rejected it in whole or in part, in some way discounted it in its entirety, including the absenteeism opinion, which was the only medical opinion that Dennis put forth that had an opinion on absenteeism.
Before I forget this, that the ALJ decision did make a factual mistake where he or she indicated that the evidence shows the claimant only had to be hospitalized once. That's not right.
Once there were 2 hospitalizations in July of 2018, Your Honor, they were separated by a day. 2 inpatient treatments from the 15th to the 17th, 15th and the 19th, and then again through the 27th.
Okay. Well, let me go back to the question I asked earlier about where the ALJ actually engaged with that hypothetical, the one that it ultimately rejected with respect to absenteeism.
The ALJ engaged with the hypothetical at the hearing, Your Honor, and then
in its decision.
The ALJ can decide which hypothetical to
Right.
include in the decision. That's correct. And did not include that one, include the third hypothetical that did not include the absenteeism.
Okay, and so the question is where's the finding in the record that it actually engaged, or what's the basis for rejecting that final hypothetical?
The ALJ did not put a basis for rejecting in the decision to put that, but that's the ALJ's decision to make as a matter of, in the first instance.
But doesn't it have to explain why?
The ALJ has to explain overall in the decision why the ALJ found from the evidence to the ability to work, here, the ability to work with certain limitations and so on, and make a logical bridge between the evidence and the decision. The decision as a whole has to do that for the final conclusion. There's no requirement that the ALJ specify in the decision, I've asked hypothetical A, B, and C, and I've rejected hypothetical A, B, and C for reasons X, Y, and Z. The articulation standard is for the decision as a whole and the ultimate conclusion. From the evidence, logical bridge to this person can engage in work with whatever limitations here, sedentary, light, and so on and so forth, with the RFC that's set forth in the decision. The ALJ has done that here, including with respect to absenteeism, because the evidence of absenteeism is the existence of treatment during the relevant period. And we know that the ALJ reviewed the treatment during the relevant period because the ALJ says so in the decision and goes through the records for the relevant period. And so we know that the evidence of the existence of treatment was in fact addressed by the ALJ because that is in the decision, Your Honor.
Okay, so, but do you concede that there's no express conclusion about absenteeism or not?
There's no conclusion in the sense of saying counsel argued at the administrative
Right.
level that there would be absenteeism. I have considered that argument, but there's no requirement that the ALJ articulate that. And there's also counsel's argument is not evidence.
But I guess he points to evidence in the record apparently of a host of visits to doctors and hospitalizations, but it just strikes me as odd that the principal issue in this case was absenteeism, and yet the ALJ at best, as you indicated, didn't consider it explicitly.
That's the principal issue now. The principal issue at the administrative level was whether Ms. Dennis could work with certain limitations and was disabled for purposes of the Act, the Social Security Act, of course. In the principal issue at the administrative level was that the ALJ is the fact finder. The ALJ had the evidence that the ALJ had. The administrative record in this case, of course, had testimony from the hearing, had testimony from Ms. Dennis, had testimony from the VE, and it was up to the ALJ to make factual findings at that level, and the ALJ did so and was affirmed at the district court, of course, as Your Honor knows. That whether someone will be absent from work for a certain period of time is a factual finding, and here the ALJ reviewed her treatment, and at this level, it's a list. Counsel has presented a list of treatment over 2 years. All of that was before the ALJ. We know that the ALJ reviewed it, and the ALJ took that into account in making the factual findings that Ms. Dennis had certain limitations, and that did not include that she was going to be absent so much from work that it would be precluded under the Social Security Act. And that's consistent with the standard that this court and others who have looked at this issue have said, and that is a list of treatments or the existence of treatments in and of itself is not sufficient. There needs to be further evidence that the claimant will in fact be absent from work. So as here, when someone is relying on, when a claimant is relying on X number of days, in this case, there are 30-ish days of treatment of all kinds, that includes the inpatient treatment, that saying there have been 30 days of treatment over a 2-year period would mean that I am precluded from work is not enough without showing that you would actually miss those 30 days or some number below that. That evidence was before the ALJ. The ALJ considered that evidence. It is supported by substantial evidence, as the district court found, and this court should affirm. Thank you, Your Honor.
All right, let's hear from you in rebuttal.
Your Honor. The ALJ ignored absenteeism and the denial. It's pretty clear the commissioner, you can tell from their argument, does not say that the ALJ sufficiently addressed absenteeism because they don't. And if the ALJ fails to consider relevant evidence, a reviewing court can't determine that the ALJ's decision is supported by substantial evidence. I mean, that's pretty basic. And there's no comeback from this failure. Right? I made this argument in our pre-hearing brief that absenteeism would rule out work. I made this argument during the hearing, and the judge ignored it. And I alluded to that before, because a lot of times you'll get VE testimonial say, oh, well, if the claimant misses more than a day of work a month, then it would eliminate work. And I think that's what the ALJ was looking for. But that's not what the ALJ got. The ALJ got something the ALJ couldn't work with. And so the ALJ ignored it. And it was that error, ignoring relevant evidence, that infected all the other decisions. It affected the RFC determination, and it affected the hypothetical, because all those are based on providing a basis.
Are the hypotheticals in these cases necessarily based on what the ALJ found as evidence? Because I suppose your colleague on the other side suggests that the ALJ can present all manner of hypotheticals and ultimately find that the evidence simply doesn't support a hypothetical.
Opposing counsel's right. The ALJs typically make lots of hypotheticals and on the tail end choose which one they think best fits the facts. But you can't ignore relevant evidence to come to that conclusion. I think, we know that in order for a vocational expert's opinion to be relevant or helpful, it must be based upon a consideration of all the records, right? So you can't cherry pick evidence and say that the hypothetical is supported by substantial evidence. You need to take everything into account. The ALJ didn't. I would like to address a couple of points that opposing counsel made. They said that, oh, well, a list is not automatically disabling. Well, we provided more than a list. We know the type of treatment. We know the location of the treatment. We know the frequency of the treatment. Right? These are all specialist appointments, at least the scheduled ones were, at VCU. And common sense tells us you can't schedule that sort of stuff on nights or weekends. None of us here have scheduled a specialist appointment, at 7 p.m. It just doesn't happen. You can't teleport from Prince George up to VCU and back. You're going to miss some work. There was going to be some amount of absenteeism tied in with this, and the ALJ ignored it. Meyer versus Astrew was a case, Fourth Circuit, where this court said that the ALJ must consider the effect of ongoing scheduled appointments on a claimant's ability to remain employed. Now, the frequency was higher there. That was 5 to 10 physical therapy appointments over the course of more than a year. But physical therapy appointments are more accessible, right? There's usually a place 5 to 10 minutes from wherever you are. And there's a little bit more flexibility. It's not quite as structured as trying to schedule with a specialist appointment. But the fact remains that this court said that an ALJ must consider, this was in footnote 3 to Meyer versus Astrew, the effect of ongoing scheduled appointments. And that's what we were arguing here. And the ALJ didn't do it. Absenteeism only appears twice. It appears in passing when the judge loops in the discussion about Dr. Nandin, but doesn't provide any specific analysis with respect to basis. And then on the last page, when it talks about kind of canned language about the VE's testimony was consistent with the Dictionary of Occupational Titles, except for evidence of absenteeism using a cane and something else. But there was no basis or analysis, which is, in passing. I would say that I would ask your honors to look at Kreider versus Harris again, because it's on point with what's going on here. The ALJ got an answer she didn't know what to do with from the VE and ignored it. In Kreider versus Harris, this court said that no allusion is made to the critical hypothetical. That one was about vision. This one was about absenteeism. And I would add, and argument posed by Dennis. So we made the argument. That was our argument in this case, was absenteeism moving at work, is a strong indication that no reference was found possible, which would permit any conclusion other than that Dennis should be awarded benefits. It's objectively in the record, and even if she were to miss half days, it would still rise above that threshold tolerance provided by the VE. Thank you, Your Honors.
Well, we thank you, and we appreciate both of your arguments in this case, and we'd be prepared to move into our our final case this morning. We're pleased, happy to hear from you.
Thank you. Good morning, Your Honors, and may it please the court. Mr. Alas was found in the United States on April 4th, 2016. And so his indictment in May of 2021 was outside of the 5-year statute of limitations, and the indictment should have been dismissed. The issue here is whether the encounter that happened in April 2016, in which Mr. Alas was interviewed by Deputy Landaverde of the Harris County Sheriff's Office, was enough to constitute being found in the United States for purposes of 1326. The outer boundaries of this issue are set pretty clearly in the case law. On the one hand, where an officer who actually has immigration authority, whether a direct federal employee or one who is designated personally and individually under 287G, when an officer like that gains subjective knowledge, the alien is found. On the other hand, when purely state officers who have no authority or no connection to federal enforcement gain awareness, the person is not found. That's Uribe Rios. This case is right sort of in between because Officer or Deputy Landaverde was.
Well, let me, did the Deputy Landaverde, was he designated or certified under Section 282, 287G?
No, Your Honor. Well, at least the record doesn't reflect that he was. They did a record search and an affidavit, and we're not arguing that he was.
Then why should the knowledge that he acquired if he is not designated under 287G?
Because
why should that qualified as having been found?
Because of the 287G agreement was between ICE as delegated authority from the Secretary of Homeland Security. It was between ICE and the entire Harris County Sheriff's Office. The designation of individual officers was only part of the memorandum of agreement. So the rest of the memorandum of agreement is record sharing.
But counsel, the difficulty is that the memorandum of agreement between ICE and the Harris County office, you can't read that to overturn the text of the statute. And the text of the statute says only, this is the federal statute, only officers determined by the Attorney General to be qualified may carry out the enforcement function. And there are 2 points I think to be made about that. That enforcement of federal immigration law, it's not a place for amateurs. The Supreme Court has said that qualified means knowledgeable about federal law, and knowledgeability means certification. And I don't think any agreement between ICE and the Harris County Sheriff's Office can can overcome that. And it seemed to me the other difficulty you face is that under your view, if any information had come to a clerical employee or a paid intern or medical personnel about your client's status, that would have qualified as a find and set the statute of limitations in motion. And
Not necessarily.
what does that do to the prior emphasis in our opinion in Santos and in the Supreme Court's opinions that says someone has to be qualified and certified, and these particular deputies were not?
Your Honor, that relates only to immigration arrest authority. So the concern here, number one, is that a person or an individual conducting an immigration arrest, a civil arrest, not a criminal arrest, is going to expose ICE or somehow to civil liability. And there's an extensive part of the memorandum of agreement relates to the liability of the officers. And that's why they want to keep tight control. The second reason they keep tight control is because it's federal policy that governs immigration. The state can't contradict that or interfere with it, as the Supreme Court described in Arizona versus United States. But that's not the issue here. The issue, Mr. Alas wasn't even arrested back in 2016. He wasn't suspected of a crime at that point. He was the victim of a crime. So the question is not whether a person has in Santos and in Arizona versus the United States, that all regarded arrest authority. When a person is found, it doesn't mean when they're arrested, it's when knowledge is gained. So the real relevant provisions of the memorandum of agreement are the intelligence sharing.
What do you do with the language in the agreement between ICE and the Sheriff's Office under 287 that says the agreement itself and the statute? You've got to overcome both the language of the agreement and the language of the statute. The agreement is pursuant to the statute, and it says ICE will delegate, quote, nominated, trained, certified, and authorized personnel to perform enforcement functions. And these were not, the deputies were not nominated, trained, certified, and authorized to perform these functions. And what troubles me about your position is that if you overturn this requirement of certification, we're going to have a vast number of personnel of all kinds and descriptions in the Harris County Sheriff's Office who come upon information about somebody's status either through triple hearsay or directly or whatever. Who knows if it's true or who knows if it's false? And we're going to be litigating hundreds of cases, if not thousands of cases across the country as to what qualifies as a find. And the agreement and the statute and the Supreme Court's case law and our case law all indicate that a find is tied to education and certification. And once you leave that rule, you're in never, never land. And it's the most litigious proposition that I've heard. And a lot of people are going to be said to have been found that may be perfectly innocent and perfectly lawful. It's when you let amateurs loose on this whole area in contravention of what Congress says and the case law says and the agreement says, you're asking for a chaotic situation.
We are not
that orderly right now, but you are asking for chaos.
Your Honor, could I
in
respond?
terms of enforcement of immigration law.
May I respond? So, no, a reversal in this case would have no effect whatsoever on what officers are allowed to conduct civil immigration arrests and their liability under state law. It has nothing to do with that. And in fact, the liability or the authority to actually conduct immigration arrests, to go out in the community and arrest people, would continue to be supervised by ICE, number one. This arises only because there was an encounter with an officer who was part of an office that had a 287G agreement, and he didn't use an alias. He gave his true name and date of birth. And in fact, the information he provided was that his employer was threatening all of the illegally present employees with being reported to ICE if they reported his severe
But counsel, the agreement to which you refer under Section 287 uses the words ICE will delegate nominated, trained, certified, and authorized personnel.
And the agreement went beyond just the statute. The statute, the 287G, does not describe the entire terms of every contract that's going to be signed between ICE and between a sheriff's organization. So here are the parts that are relevant that are put in. They provide material support and office space free of charge to ICE, which indicates they're being integrated together. And especially important is page 284 of the joint appendix, the data sharing provisions. It says HCSO, that's the Harris County Sheriff's Office, not individual officers, but the office will provide specific tracking data and or any information, documents, or evidence related to the circumstances of a particular arrest upon request. And later it says HCSO, again, this is the organization, not individual officers certified, agrees to cooperate with any federal investigation related to this MOA to the full extent of its available powers, including providing access to appropriate databases, personnel, individuals in custody, and documents. So that made Deputy Landaverde, that made his report immediately available to ICE under the terms of the agreement. That agreement made HCSO into the ears and eyes of ICE. And when a person who is, this isn't involving an administrative assistant or a paralegal.
Well, what about that? What about those examples?
No, those examples, Your Honor, I think would fall under agency law. So if an administrative assistant finds out, that doesn't necessarily impute the information to the entire organization. What we have here is Deputy Landaverde. He is certified not under the 287, but he is a deputy sheriff. So he exercises the powers of the sheriff, and he writes a written report that goes into a database. So both the report and he himself are part of the knowledge of HCSO. Whether that knowledge would
this opens the whole door. If we buy your theory, there are going to be hundreds of thousands of people saying, we were all found. We were all found. This and that piece of information came to this and that individual. And oh, by the way, they are officially employees of the Harris County Police Department, because your view of the party to the agreement would include everybody in the Harris County Police Department. And you're going to have people all over the country, in every city in this country, in this jurisdiction in this country, said we were found more than 5 years ago when our illegal status was brought to the attention of this person or that person. And we're going to have to litigate those factually and say, well, I mean, what information was brought? And, you know, where and to whom was this brought? And this is over 5 years ago. Where is the person to whom the information was brought? It is a prescription for total chaos.
Your Honor, I litigated 1326s as my majority caseload for 7 years in the Southern District of California. And I would be absolutely shocked if this same issue, that a person encounters an officer from a 287G agreement more than 5 years before the date of the indictment, I would be shocked that if it arises more than once every couple of years. There aren't hundreds of thousands of 1326 prosecutions, even in the last.
We can't rewrite the agreement. The agreement, as you described it, was with the entire Harris County Police Department. And because you say that they're a signatory to the agreement, that includes everybody, including a paid intern or including a clerical personnel. They're all
it includes
to the agreement as you have described it.
No, Your Honor, it includes anybody who under ordinary laws of agency law incorporate, which are common to corporate law, anybody whose knowledge would be imputed to the organization otherwise, under just.
All right, that in itself, ordinary laws of agency, that in itself is a litigious phrase. The Supreme Court and our precedent in Santos and Uribe Rios have tried to set forth a clear rule that would avoid all the questions your position raises.
Well, Your Honor.
And the core of the clear-cut rule is a certification requirement, and the certification requirement is earned by attendance at a particular in immigration enforcement. And you're going to draw all these kinds of things into question. I just can't imagine how chaotic the implications of your view are.
Your Honor, it draws nothing into question as far as the immigration enforcement activities happen. The only time this arises is when it comes into a court and the government indicts on a 1326. I see my time.
Thank you. Mr. Atlias.
Good morning. For the defendant to secure dismissal of his indictment on timeliness grounds needs to demonstrate he was found under 1326 in April 2016.
Can you speak up a little bit for me?
And he can't do that for the following reasons. The first is that the defendant's stipulations contradict any kind of actual discovery theory. Judge Wilkinson, was that a question?
Yeah, go ahead. I can hear you fine now.
The defendant's stipulations contradict any kind of actual discovery theory that he makes. We know from this court's decision in Uribe Rios that an alien is found under 1326 when federal immigration authorities discover his presence in the country. But here, the defendant was found by Deputy Landaverde in April 26, found using that word colloquially, in April 2016. But Deputy Landaverde was an ordinary Harris County Sheriff's officer. So he wasn't a federal officer, and the defendant stipulated to that effect. And so much like Uribe Rios, the defendant can't show that in April 2016, federal government had any knowledge of his presence in the country, let alone his status. And also like Uribe Rios, that decision forecloses any attempt to impute Deputy Landaverde's knowledge to unspecified people in ICE. So I think a straightforward application of Uribe Rios really resolves this case. But of course, there's a secondary theory, which is the theory that even though Deputy Landaverde wasn't himself designated under 287, well, his office is part of that agreement. So he was in effect found by that office, even though Landaverde wasn't designated. And
I was going to say this case has all kinds of problems because there's a collateral attack being leveled against a removal order in 2011. And collateral attacks on removal orders are highly disfavored, and you have to meet all three of the criteria. And it's doubtful that any of the three criteria have been met to sustain a collateral attack. And our recent decision in United States v. Manley has indicated that malicious wounding is not a crime of violence after Borden, and indeed our circuit has always, in 2011, it followed Borden in saying that recklessness is not a mens rea. So you sometimes in these cases you have to step back just a second, and you have somebody who came into the country illegally. He was convicted of an aggravated felony, which was malicious wounding. That was a crime of violence. He then waived his right to contest the charges. He was removed to El Salvador. He re-entered the country illegally. And you have to ask yourself, reading all these statutes and everything, is this the kind of individual that our country, which is welcoming to immigrants and wants and finds renewal and vitality in immigration, is this the kind of individual that Congress would want? And when you look back over this whole record and the rest, you have to answer that question in the negative. Isn't that correct?
I agree, Judge Wilkinson. You referenced this court's decision in Manley. We thought that the malicious wounding issue was resolved even before Manley based on Moreno Osario and Rumley. But this court's decision in Manley definitely forecloses the defendant's challenge. We filed a 28J letter on Manley in, I think, November. Defense counsel hasn't responded to it. I'll let him make his own arguments. But in our view, that resolves the entire collateral attack because, as you pointed out, you have to meet all three of them. Can't meet D3, then the entire challenge fails. And so returning for a moment to the statute of limitations challenge, we went through our brief, all the reasons why we think the defendant's theory, secondary sort of backup theory, fails. And Judge Wilkinson, you pointed this out, and the text of the statute, first and foremost, forecloses the defendant's challenge. Is very clear. The statute contemplates a narrow program where the Attorney General will select specified nominated individuals. And unsurprisingly, for a program like this, there's a training requirement, there's a certification requirement, there's a requirement that the officers have knowledge of and comport with governing law. And the memorandum is to a similar effect. It's full of terms and conditions regarding the nomination and certification and training of specified officers. And there's nothing about the statute or the memorandum that suggests that once office enters into one of these agreements, well, everybody is sort of swept up within it and has either immigration power or responsibility. On the topic of the memorandum of agreement, I would like to address something that defense counsel raised here today and also in his reply brief, which is the theory that there's this cooperation agreement or knowledge sharing. And the reference that the defendant makes, he cites JA 285 to 286. And I think that defense counsel has just misread that provision. And again, it's 285 to 286. The provision the defendant cites about cooperation and information sharing is in a section of the MOA called liability and responsibility. And it addresses, as it says in the first few lines, what happens when a participating officer is subject to a complaint that could turn into a criminal case or a civil lawsuit. And so the entire page addresses what happens in that circumstances. It first addresses Federal Court Act claims, then addresses how a participating officer can get DOJ's civil division to represent him. And then comes a line the defendant references, which is that the Harris County Sheriff's Office agrees to cooperate with any federal investigation and share information. That has to do with when a Harris County Sheriff's officer who participates in the program is himself subject to an investigation. I don't think it means what the defendant thinks it means, which is that there's this knowledge sharing to enforce immigration. That's not what it means. And that's why the last line of that paragraph cites Garrity, which is a case about internal investigations. And so with respect, I think the defense counsel just misread that provision. And again, Judge Wilkinson, you referenced this earlier. One of the big practical problems with the defendant's theory, and doesn't just apply to the Harris County Sheriff's Office, but it applies to any sheriff's office that has a 13287 agreement, and there are about 130 of them, which is presumably many, many tens of thousands, if not hundreds of thousands of employees. You could just take the Harris County Sheriff's Office. On the defendant's theory, all of those people, whether they know it or not, have the power, not just to find, because we have to remember what we're talking about. We're talking about triggering a statute of limitations at the end of the day. All these people have the power to find aliens and trigger a statute of limitations, whether anybody in the federal government knows it, whether they even know. And that just...
Well, this case comes to us with a prescription for chaos, and the chaos has a capital C. I just can't imagine the number of finding problems that would be unleashed with this. I mean, it's chaotic, and just to let amateurs who have no knowledge of immigration enforcement to let them loose over the border and turn them into deputized immigration enforcers or finders or whatever. The whole thing makes me it makes me recoil a little bit as to what the consequences would be.
I agree, Judge Wilkinson. I think it would lead to a really bizarre and unhinged statute of limitations scheme, which at the end of the day, as applied to 1326, is what we're talking about. I'd be happy to answer.
I'm going to let my colleagues have questions. I'm going to give them whatever time they need to answer. And otherwise, you may sit down. Judge Diaz, Judge Cogburn, do you have any questions of this gentleman?
I do not.
I do not.
Thank you, Your Honor.
Thank you.
Thank you.
First thing I have to note, Your Honor, Your Honor asked, is this the kind of individual that this welcome country that Congress would want? Is not at all a question that is before this court and inappropriate even to consider. The legal question is whether the discovery of the true name, date of birth, and immigration status of an individual by a deputy officer of an organization that has agreed in writing to be the eyes and ears of ICE is sufficient to say that that person was found in the United States. That is it. I will briefly mention the collateral attack. We did not respond to the 28J. Manley does cover that. Malicious wounding under Manley, which is published, is a crime of violence. That'll have to wait for en banc review if this court does not remand on the statute of limitations theory. Going back to the statute of limitations theory, though, the government mentions in page 284 and 285 of the record, this agreement is key. And this is in a separate paragraph. It is under liability, but it's not just liability, it's liability and responsibility. And it says HSCO agrees to cooperate with any federal investigation related to this MOA to the full extent of its available powers, including providing all the other information. And then only later is when it talks about the HSCO agrees to cooperate with federal personnel conducting reviews to ensure compliance. And that's in a separate part later on. The initial part about information sharing is its own separate paragraph. And the previous paragraph, page 284, indicates that that the HSCO, and this is under the heading reporting requirements, will provide any information, documents, or evidence related to the circumstances of a particular arrest upon request. This would unleash no chaos because it would not affect one iota immigration enforcement. It would have an effect only on the statute of limitations, in which case, I should note the indictment date here is May of 2021, and the found-in date is August of 2020. So there's a 8-month lapse between when they say they found him and when they actually got an indictment in this case. 8 months of that delay could have easily been avoided, or would have easily put this case within the statute of limitations. Second, if the question that the court is asking about the chaos of opening up 287G offices, there are only 130, and this is out of all local enforcement in organizations in the entire country. Look at what happened in Harris County, Texas. They had this agreement, they renewed it in 2016, and then they let it lapse. And they're no longer party to any 287G agreement. That is a political question. If the voters of a particular locality want their law enforcement officers to operate as the ears and eyes of ICE, to provide them office space, to detain, and that's another provision, they get to detain individuals on behalf of ICE, then the voters can vote for people that will enact those. The beginning of this agreement, it's even in the record, is the order of commissioners of court. This was adopted and approved by an elected body. So this will not unleash any kind of chaos, and it leaves the decision about how law enforcement, local law enforcement operates and what sorts of responsibilities they want to take on as relating to immigration. And it leaves that up to the voters in every local circumstance. The simple facts here are, and I would be shocked, we don't have any information about when this report was pulled or who saw this report. Nobody from ICE testified from down in Harris County, but I would be absolutely shocked if an officer interviews a man at the hospital who's bleeding from his eyes, who says that his employer beats him and others regularly, that he threatens to report them to ICE if they complain about it. And I would be shocked if an officer did not actually report that to ICE. Employing people who are here illegally is itself a crime under 1324. This individual was actually arrested for the crime of the assault that he committed on my client. And when it involves immigration, and especially these threats to report people to ICE, that's going to trigger ICE involvement if the local law enforcement reports this back. So we don't have a record of when exactly this report was viewed by anybody, but it's completely reasonable to assume that ICE saw it at the time. Now, whether they want to take enforcement action is ICE's decision. Gathering the information and giving it to ICE triggers the found-in. Whether ICE acts on it is up to them. And they have lots of enforcement priorities. It's perfectly possible they decided that, well, this man is a victim of a crime, and our real priority is getting his boss. So we don't want to arrest him and subject him to the immigration process right now.
We don't have any of this in the record.
Not at all, Your Honor.
But how does that help you? I don't understand.
Well, because it wouldn't trigger chaos. It would leave the decisions, Your Honor, in the hands of the individuals who are supposed to make those decisions. I see my time is up.
All right. We thank you. Thank both of you. I'll ask the courtroom deputy to adjourn court until tomorrow, and I'm going to ask the courtroom deputy to put us into conference, and we'll take a 10-minute, 5 or 10-minute recess, and then we will be ready to confer.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.